All right, Lee, would you like to get us started here?
Sure, I'd love to. Good morning, everybody. My name is Lee Stokes, and I am the Vice President of Operations for the Northeast and Orlando regions for Vesta Property Services. This is our second webinar partnering with the law firm of McCabe Ronsman, specifically discussing the impact that the COVID-19 pandemic has had on our community associations. Welcome back to those of you that joined us on the first webinar, and thank you to those of you that are joining us for the first time. McCabe Ronsman is a full-service law firm with 7 attorneys representing community associations throughout the state of Florida. It is my pleasure to introduce to you now the 2 attorneys from McCabe Ronsman who will be facilitating our discussion this morning. First is Ed Ronsman, who is a partner and is board certified in condominium and plan development law. Ed has devoted his entire legal career to representing community associations throughout the state. The second is James Roach, who is also a partner with McCabe Ronsman, representing community association and developers. So we're glad you're all here this morning. We look forward to a very interesting and informative discussion. So at this point in time, I'm going to turn it over to our expert panelists, Ed and James. Thank you.
Thank you, Lee. So thank you, everyone, for attending. I know it's been, sometimes it feels like the time has gone by really slowly, and sometimes it's gone by really quickly. So it doesn't feel like too long ago, I guess, that we did a webinar that a lot of you, I think, attended when this all started. So we're kind of here, we're looking at it. Everybody's aware in Florida of the phase 1 reopening starting yesterday. So we thought this would be a good time to take a look at where we're at. Some things that we've seen as attorneys, some questions that we've received from some of our clients, so we can try to give you some information. What you're not going to find today is probably concrete black and white answers, and that's just kind of the nature of this, obviously with everybody facing this for the first time. But the best thing that we can do is give you our best general advice from a general standpoint. Obviously your community documents are going to control on certain issues and would require more specific looking into. But we're going to try to give you the information that we have today, and we hope that you find it informative. For those of you that have not yet become Zoom proficient, I think a lot of us have had to become in some way or another, whether this or some other software. We have, if you look on your software, there's a Q&A button. That's the best way to ask questions throughout. I know we received some emails with some questions that are all pretty similar, and we'll be happy to try to answer those. They're all pretty much related regarding the reopening of the amenities. But if you can hit the Q&A button, that means that a question will pop up for us, and we'll be able to answer whether while we're going throughout or we might hold it to the end. So if you can bear with us on that, that would be great. So at this time, I'm going to share our PowerPoint. We're happy to provide a copy of this afterwards if you want to email us. Our emails are on the last slide, so we'll have that for you as well if you have any board members that maybe couldn't attend. I know that also Vesta is making this recording available, and that usually takes a day or two, but that's another thing that we will replay this, so you'll be able to watch it too. All right. So we're going to go through the update of reopening Florida in your communities. Some of the things we're going to talk about, these are kind of our agenda items for today. The current orders that are in place, Jim's primarily going to walk us through that. We're going to talk about reopening amenities in the community. That kind of ties in with some of the orders that are in place. We'll talk about some contractual issues, some things that we've seen pop up as a result of this, and then we'll talk about the long-term effects that we've seen, kind of some of the things that we talked to you about if you came to this about a month ago, some other things that we're seeing, and we'll see where we go from there. So the current orders in place, Jim, can you walk us through kind of the most recent executive order and the phase 1 reopening and how that applies?
Sure, and what I'm focusing on are basically 3 issues that I think are, most important or most related to the community association world. Executive Order 2112 did some other things. It relaxed some requirements. It also imposed some requirements on local jurisdictions. But there are 3 main issues that I would consider to affect community associations. One are the amenities and the amenity facilities associated with particularly residential associations, vacation rentals, and preemption, meaning whether this executive order supersedes orders from local governments. So starting with the amenities, I'm talking about things like gyms, fitness centers, pools. The executive order does not require amenities of residential buildings to be closed. And I'm talking about the state executive order. But you still need to look at local orders from your local governments, depending on where you're located, to determine whether there are any additional local governmental restrictions on your facilities. And we'll talk a little bit about that more later on the preemption part of this. So what Executive Order 2112 did was it extended 2071, but 2071 specifically did not apply to an amenity of a residential building, which I think probably most people here or most communities here will fall in that category. Oops, sorry, that's okay. So another important point, well, on that note, you were likely never required by the state executive order to close your amenities. Now, again, whether the association is legally obligated to close an amenity and whether it should close an amenity are separate questions. So going to the next issue of vacation rentals. So Executive Order 2112, the recent one, extends prohibitions on vacation rentals as provided by Executive Order 2087. But it's important to understand what vacation rentals are or how they're defined in this specific order. So Executive Order 2087 prohibited parties engaged in the rental of vacation rental properties, and it referenced a specific statute in defining that. It also prohibited them from making new reservations, but there are some exceptions. For example, people that are providing, like first responders and that kind of situation. Provides that the prohibition shall include the rental of any house, condominium, cooperative, or dwelling unit that is also a transient public lodging establishment as defined by law. So then we have to look at what transient public lodging establishment is, and we'll do that on the next slide. But considering the exceptions, so people performing military services, emergency, governmental, health or infrastructure response, or this one is interesting, travelers engaged in non-vacation commercial activities, those types of rentals are not prohibited by Executive Order 2112. And the word non-vacation commercial activities is not defined anywhere else in that order. So that could be, subject to argument interpretation.
One thing I wanted to add, this is an issue that came up recently where there was a community that we represent, and there was a request for what would normally be considered a vacation rental, a short-term, I think it was a 2-week rental, and they were two individuals that were involved in an industry that does provide some type of agricultural service. They had a letter from their out of state. The issue there was we found out that not only were those two people coming in, but they also had 12 other family members there. And so the question then, are they using that letter? Are they using that to get around, try to use that as the exception to the vacation rental? It's unclear. The other thing is, are they actually performing that service while they're here, or are they using that they have performed that service, but they're not actively performing it in the area where they're requesting to have this short-term rental? So there are some interpretation issues that come into play, and we'll talk about some of that maybe from an enforcement standpoint, but that was something that just came up recently for a community that I work with.
So these are the two statutes that were referenced in the actual executive order. I'm just going to go right to the second one, transient public lodging establishment. So the first one is a vacation rental that defines vacation rental, relatively intuitive, but it also says it must be a transient public lodging establishment. Well, what is that? Generally, if there's a rental more than 3 times in a calendar year for periods of less than 30 days or 1 calendar month, whichever is less, or which is advertised or held out to the public as a place regularly rented to guests. Okay, so you have some timing limitations there. Is it just one short-term rental in a year period for fewer than 30 days? Well, then you're not a transient public lodging establishment, and that executive order likely wouldn't apply to that particular rental. So to summarize some of these statutory criteria that are incorporated into the order, if the rental is to an exempt person, which we just discussed on the previous slide, if the rental is for fewer than 30 days or 1 month, but the unit is not rented for more than 3 times in a calendar year for periods of fewer than 30 days or 1 month, or the rental is for a period of greater than 30 calendar days or 1 month, then Executive Order 2112 doesn't prohibit that rental. But an important point to understand is, what the executive order might prohibit and what the association's roles are in this situation are 2 different things that need to be considered. And the executive order does not permit a rental that would otherwise be prohibited by the governing documents. In other words, these are words of prohibition in this executive order. That doesn't all of a sudden mean that, well, if your community requires, for example, a minimum 6-month rental period, that all of a sudden first responders and people like that can try to come in here and vacation rent. They must comply with your governing documents. This executive order does not supersede the provisions of your governing documents regarding rentals. So a couple of final points on what vacation rentals means to your community or how this might affect you. If the association doesn't have tenant or lease approval authority in its governing documents, the executive order doesn't grant any enforcement powers to the association. So in that case, if there aren't any other provisions in your governing documents regarding rental regulation or minimum lease terms or things like that, then it's not the association's role in this case to attempt to enforce executive orders or law. Do what is suggested in the administrative order, which is contact law enforcement, or you can contact the DVPR to report the potential violation for the vacation rental company. So it's almost like a licensure complaint. And if the association does have tenant or lease approval authority, or if there is a compliance with law provision in your governing documents, such that we can sort of incorporate the executive order potentially, then your association might have the option of either contacting law enforcement or the administrative agency, the DVPR, if executive order may have been violated, or potentially instituting your own rule enforcement or covenant enforcement proceedings, or potentially both. What we typically recommend is, hey, let's try your cheapest option first, right? If you have the option to contact law enforcement and that might accomplish your goal, maybe start with that option. Yeah. All right. Okay. So the issue of preemption. So does the governor's order 2112 prohibit preempt or supersede local ordinances or local law? So unlike the couple of executive orders 2091, which was clarified by 2092, nothing in executive order 2112 expresses any intent to preempt or supersede local law, which is why we still need to look at local law in your jurisdictions. Similarly, most of this executive order expressly does not apply to Miami-Dade, Broward, and Palm Beach counties. So basically the governor said, hey, you guys have an interesting or unique part of the problem there, so I'm going to let those local governors the mayors and so forth, handle that in the way they deem appropriate. I'm not going to preempt them from the state standpoint. And also attached to this executive order, there are frequently asked questions. And those, one of the questions was, hey, does this order preempt local authorities? And it expressly states that it does not. There's no intention in this order to preempt local authorities. So they're allowed to adopt requirements directly on businesses, operations, venues, buildings, beaches, parks, things like that. So you still need to look at those. So that brings us to the bottom line, which is the association, although you need to be conscious of these state orders, you also need to recognize that there may be local orders and ordinances in your jurisdiction, and you need to look at those too before taking any action with respect to the virus.
So I saw a couple questions come in. I think it might be a good time before we move on just to address a couple of them that I can see. And some of these we'll get to later. But Chuck asked, can restrictions on rentals be placed in Exhibit E of the covenants? Without knowing what Exhibit E is for your covenants, I think the general question is, can you place restrictions on rentals? We almost always advise that is placed as a member vote in your covenants, whether it's your declaration of condominium or your declaration of covenants and restrictions, because it fundamentally affects the ability of how you're using the property. And it most likely you have a provision. If there isn't anything on rentals, you probably have something that says that it's for residential purposes or something like that. And by placing a restriction on the ability to rent as a rule, for example, that might deem to be in conflict with your otherwise ability to use the unit. I'm not saying that you couldn't pass as a rule, but it's where we always recommend to our clients that you amend that, which typically then requires a membership vote when you're amending your declaration of condominium or your declaration of covenants and restrictions. And then kind of a follow-up, kind of tagging along with that, Kathleen asked, can the vacation rentals be stipulated in the bylaws and not in the covenants? Again, it just depends on the language that you have in your covenants, your declaration, which is your highest priority document. But we always recommend amending your documents to provide for that through a member vote, because I understand why you would want to do it as a bylaw change, because a lot of times the board can change the bylaws as opposed to requiring membership approval. But you likely have a provision in your documents that you could find that if you try passing it as a bylaw change or a rule, that it's going to be a lesser priority document that's going to conflict with some authority that you have or the right to use your property in your declaration. The other thing to know too is, even if you go through the process of amending your declaration and you receive membership approval, if you've attended this before, you've probably heard us say this, but if you're a condominium, any change, if you place any prohibition on the ability to rent, or if you limit the amount of times that you can rent in a year, even if it passes the threshold for, let's say it's 2/3 membership approval or 3/4 membership approval, it only applies to those owners who vote in favor and then any future owners of the property. So it doesn't apply to anybody that votes no or doesn't vote while they still own the unit. So that's the other thing to consider. That isn't in place for HOAs. That's only right now a statutory provision in the Condominium Act that says that, hey, even if you pass this by requisite member approval, it still only applies to this group of people. So consider that too, even if you're going through and trying to update your documents. All right. And I know we have a couple more questions. We'll make sure to get to those too. So reopening amenities in the community, Jim has kind of touched on some of this in terms of what are the orders that in place, and you could tell that, well, there really isn't a state order that ever closed down your community pools or your amenities. You may have some local orders. I know not really anything up here in North Florida. For the people that are on this is really the North Florida from Orlando and Gainesville, north through Jacksonville, that I'm aware of. There isn't anything that ever required condominium and homeowners association to close down their amenities. So then it comes down to really a board decision. And we've been asked as a law firm, can you tell us what we should do? And our response is, which might be a little bit frustrating, is we can't tell you if you should or shouldn't do it. The best thing that we can do is say, what are you leaning towards? And we can tell you the pros and cons of that approach. And I know that, again, that might be lawyer speak and that might be frustrating to hear, but the reason for it is that there's no black and white answer for this. And so the best thing that we can do is say, look, if you decide to reopen your amenities, for example, let's say you close them down, I certainly think that there is authority for the board to reopen the amenities. And in fact, the owners have a base right really through the governing documents that they have an easement over the common areas. So that's a general right that they have always had to use the common areas, subject to any reasonable rules that are typically provided in your documents. And so really you're opening it back up to something that the members should have access to. The question then is, if you do that, what type of notification should you provide? Should you have conditions placed upon it? I've had some associations that are looking to adopt rules, maybe limiting the number of hours, limiting the people that are able to use it. There's pros and cons for doing that as well. Can you distinguish between only residents being able to use the amenities versus residents and guests? On this bullet point, the first one here, it says if emergency powers are exercisable, which is debatable, it includes the ability to determine property off limits to use. So where we're going from is, if you attended our first webinar, we talked about the emergency powers under the Condominium and the Homeowners Association Act, which mentioned that in the event of property damage, is the way that the statute reads, one of the things is that the association can determine property is unavailable for use, and it doesn't really distinguish between well-only owners versus owners and guests and invitees. It just says property unavailable for use. So that's what associations have been using generally. There's a question as to whether or not the emergency powers actually apply in the event of a pandemic. The reason is as I said before, it says in the event of property damage. You can tell that those emergency powers were, and that statute was adopted with hurricanes in mind. Basically, hurricanes, tornadoes, natural disaster where there's actual property damage that's taken place, and whether or not you can consider property to be off use. Obviously, we don't have property damage right now. It's a pandemic. We actually don't want people to use the property. That's the idea because of the spread of the disease. So there is some debate. The DBPR, which is the Department of Business and Professional Regulations, the divisions of condominiums, timeshares, and mobile homes, has come out, and they basically said, we treat the emergency powers as applying in this circumstance. There's a question as to whether or not they have authority. They even said that, what was the language, Jim? Something like, it's suspended as to only property damage. They're basically expanding the scope of the statute without actually amending the statute or any type of amendment there, right?
Right. It's an executive branch trying to recraft legislation, which is what makes it so questionable. The whole part of the statute and the emergency powers statute, which says in response to damage caused by an event, and they tried to basically kind of strike through that and say, well, you can still use these powers, right? It's just an opinion of an administrative agency. It's not reliable enough to, it's not conclusive evidence that these emergency powers will apply.
So where we're going with that is, you have these emergency powers. It's possible that there could be a lawsuit at some point where somebody's very upset that the association continues to close down the pool, the clubhouse, the tennis courts, the basketball courts, and they file a lawsuit. This gets in front of a judge. And at some point, there may be some type of an appellate decision that we can rely upon, or at least look to, depending on which DCA you're in terms of whether or not it applies specifically. But until then, we say that it could be possible to use those emergency powers. I think that it's certainly, there's a good argument for it, and I think you could see a change to the statute probably as soon as next year would be my guess in response to this. But it's questionable as to whether or not that applies. So I think it does come down to a board decision. What we've been advising our clients is if you are opening up the common areas, we've been recommending using some type of disclaimer language, essentially stating, hey, we are reopening these, but they are using it at your own risk. We have some disclaimer language that if you contact us, if we work with your community, we can work with you on it individually. It is kind of a community by community thing, depending on the amenities that you're opening, what you're wanting to do. But we have worked with some communities to provide some language there, which basically the message that you're trying to send is, it's not our job to go down and wipe down these areas and to prevent the spread of this disease. That's not something that we are responsible for as an association. That's not a duty that we're willing to undertake. And so by opening these, we're not warranting that they're free from disease or any type of communicable disease or virus or anything else like that, that you're using it at your own risk. I had one community that said, well, we're going to provide you with hand sanitizer when we can, and we're going to wipe it down on a certain number of times each day. And I've advised against advertising that. I think you can do that. I certainly think that if you choose to do that as a board, I think that's certainly permissible and probably something that I guess I could say could be recommended from a standpoint of, if it's part of your normal, if you've got cleaning or maintenance or janitorial services, it's certainly acceptable to increase those in response to this. What you don't want to do, in my opinion, and what we've been advising our clients, is advertising that, saying, hey, we're taking care of you. We're going to take care of this. We're going to wipe this down. We're going to protect our members and our guests from the spread of this disease. Because guess what happens? If somebody contracts it, a lawyer is going to come after the association and say, doesn't look like you did too good of a job in doing that, did you?
Right. Here's where you promised it.
Yeah. So really, the board has broad powers over the administration of the common elements. It's really a business judgment rule. Now, I'm going to flip that and say, what if you choose to keep your amenities closed right now? Is there authority to do that? I certainly think there's ample authority to do that as well. Is there a black and white answer that says you're allowed to right now? The answer is no, because the question is whether or not those emergency powers apply. You have arguments, and Jim, why don't you touch on it a little bit? Just, we were talking a little bit before this started on a case where I think it involved like a personal trainer, right, with being aired.
Right. So some of what our communities are attempting to do is say, well, we just want to open it right now for just our members and just our owners and residents perhaps, but no guests, right? And there's actually some case law on that. And in part, it depends on the provisions of your governing documents, and specifically the easement provisions, which are most likely going to be in your declaration. And in some cases, and in many cases, in fact, your declaration will grant easements to members, tenants, guests, and invitees. And that's a pretty broad class of person. So if you try to then carve out, well, we're going to cut half of these people out from exercising their easement rights, that you might be placing yourself in a bit of a difficult or tough to defend position. So there's one case that people in the community association law world have been discussing, and it's a case where an association they adopted a rule prohibiting personal trainers from being in the premises for those who were compensated. And I can think of many reasonable bases for having that rule, one of which that might not be covered by the association's insurance policy. But taking that aside, the court looked at that, and what it did was it looked at the easement provisions of the governing documents, and it said, no association, you had no authority to adopt this rule because there's an easement and a superseding document, your declaration, and that easement's in favor of the residents, guests, and invitees. And that personal trainer is an invitee. We don't care whether they're being compensated or not. They're still an invitee, so you didn't have the authority to adopt that rule. So we're worried, or we're concerned that case might be applied in these circumstances. So, nevertheless, some of our clients are still adopting those rules, or still doing that on a temporary basis. And what we hope is that people aren't going to be able to challenge it quickly enough before all of this blows over, and it's not going to be an issue anymore.
Yeah. So again, there's pluses and minuses for both sides. Obviously, I think to summarize, for reopening, disclaimer language, use at your own risk. I know we had a question, and I want to get through, because I know a lot of the questions that we have are regarding amenity use. Somebody had a question of, are there suggestions on how to open them up? How many people are allowed at one time? Same question goes for events. Does the community have any liability if we have events or food trucks? So I've seen some communities that have said, well, Ed, I think we're going to reopen, but what we're doing is we're removing a lot of our chairs to make it less likely that people can grab the chairs together and sit together and violate the social distancing recommendations. I certainly think removing chairs is a reasonable option if you choose to do that. Placing limitations on the number of people in the pool at one time. I mean, you already have, from a safety standpoint, that already typically is in place. Could you choose to adopt that as a temporary rule right now? I certainly think that that's a reasonable rule. Again, it comes down to, though, it could be subject to challenge. Do I think that it's likely? It's a risk tolerance thing from the board, I guess. Hey, I think that we want to open these up, but we want to have certain restrictions. We want to remove some of the pool furniture, and we want to say, hey, we only want to have 50 people in here at one time, even though we normally have a capacity of 150 or something like that. Do I think that that's a reasonable rule? I think it could be. I think, could it be subject to challenge? Of course. It's just then, is the board okay with doing that in an effort to try to curb this, but still open things up, and then withstand, understand there could be a challenge made by somebody later on. Where I think you could see more challenges are probably in the communities that have vacation rental programs. If there's a lift on the vacation rentals, but if there's still some type of a closure of the amenities, that really goes to people's pocketbooks more than even with residents that are frustrated of not being able to use their amenities. Because if you're a renter, if I own a unit and I'm put in a rental program, but my community is one that is being more strict on not reopening pools and the fitness center and everything, that could go directly to the ability for me to be able to rent my unit, and that affects me more from a dollar standpoint than maybe my personal use. So that's where there might be more likelihood for a challenge there. I know I've heard from some of our managers that I work with that are on site that have vacation rentals, and they're basically saying this is some of the toughest times I've ever had in my job right now, is having to figure out, how do I protect my members, even if it's not their actual obligation, they still feel that responsibility, versus, also, protecting in a way the owners, or, keeping the value of these units up if they're operating a rental program. So it's a tough thing. And I think the best thing you can do is, hey, what do we want to do? Talk with our manager, talk with our attorney, and then work through the best way to accomplish that. We can give our best advice and help guide you if you're going to go a certain direction. If you're going to go that way, we'll help guide you as best we can from a communication standpoint and how the messaging is provided. All right, let's see. I know we have more questions. I'll make sure to get to some of those. Notice to owners, any communication provided to owners should be carefully worded. We've talked about some of this. Generally recommend including some type of disclaimer language regarding the use of common areas and the common elements. The biggest concern is setting the expectation or belief that the association is undertaking a duty to prevent the spread of the disease. That's what our biggest concern is. And I know that it's a push-pull of wanting to make sure that people don't get it, but also not making it seem like we're protecting ourselves from a liability standpoint, that if somebody contracts it, they can't point back to us and say, well, you said you're going to prevent the spread of this, and it doesn't look like you were able to. I want to talk about vendor access a little bit. I think that now that it looks like we're kind of titling this as reopening, for example, I've had some communities that were trying to deny access to vendors or severely limit it. I've advised against that generally throughout, because my concern is that those vendors, if they're providing a service or if they're delivering something, typically there's a contract or some agreement in place between them and the owner. And if they're not able to perform, there may be a monetary impact on the owner that might give more likelihood for a challenge against the association. It's a more tangible potential claim than an owner could make. The other thing that I'm concerned with is you never know who you're denying access to. And I always give this example of, what if they're providing medical supplies or something like or some type of essential item that the owner needs because they're not wanting to leave. And if you deny that vendor the ability to come in, guess what happens if somebody dies or somebody's injured or something happens to them? That's even a clearer case for liability than if somebody might contract the disease and how you can actually prove that it came from the association or not. So Jim, you want to talk a little bit about maybe some liability issues from like a vendor standpoint? I mean, I know some communities, like some condos, immediately they closed down and were locking out any vendors even from doing renovation projects, notwithstanding the fact that somebody could literally go in through the parking garage, have to open one door, and they'd be able to get to a unit, for example.
Right. So that's kind of one concern with just blanket prohibitions. I think the makeup of your, the physical structure of your buildings, whether you're an HOA, whether you're a condo, I think a lot of those things should play a role in that kind of a decision. I think we're generally cautious about suggesting that we limit vendor access. And we're talking about vendors. We're not really talking about the association's landscaper. We're talking about, construction projects that unit owners or homeowners might have going on and so forth. And perhaps there's a least intrusive manner or a less intrusive manner to try to address those concerns. Maybe you try to work with that company and say, hey, can you wear some face masks, have your personnel wear face masks? Is there something you can do short of prohibiting them or trying to limit the number of people? Because again, we're concerned with owners having, and contractors as well, having contract claims or tortious interference claims or things like that, predicated on the association's interference or prevention of those parties being able to perform their contractual obligations. So that's our main concern.
Okay.
Yeah.
All right, so going into some contractual issues, some of the things that we've seen, maybe vendor agreements, if the association has some type of a vendor or contractor agreement if they're performing work. I give this example. I had one community that's been going through with a big exterior, it's a big condominium association that's going through a painting project and exterior repairs that was already signed off, work started before all this happened. And so there are some concerns, though, understandably, from the board and from the membership that are there when they see work crews coming in of 20 to 30 workers coming in, and how that vendor is handling, control. How are they? What procedures do they have in place? And the ultimate thing is, very rarely do any of these contracts have anything regarding pandemic language. Although I think we'll see that probably going forward as part of the anything regarding pandemics, whether it's in your insurance policies and what policies you have in place if there's insurance coverage, but also just vendor agreements. We're going to talk about force majeure clauses, but really they're going to be addressing pandemics more. It's likely that you don't have anything in your contracts that allow you to dictate, for example, if there's a crew of 30 workers, can you say, hey, we don't want 30 workers here at one time. We want you to limit it down to 10 workers. And we want to make sure that they're all wearing masks, that they're all wearing gloves, that you take their temperature. Ultimately, I don't know that you can require that. Now, I say that there may be potential cause of action if, from a negligence standpoint, although typically if there's a contract, there isn't really a cause of action potentially for negligence. It just depends. You would want to place them on notice. From that standpoint, though, it's usually a good business practice. Most of these vendors, they're not going to want to be remembered as ones that say, I don't care what you ask us to do. We've got a job. You got to pay us, and we're going to have our workers out there. And I'm not overseeing, whether or not they're practicing social distancing, whether or not they're washing their hands before, and using hand sanitizer, all that stuff. Most of these companies are going to want to have your business going forward. And I think if you ask them, most of them will probably provide you with, hey, this is our internal process that we have in place to make sure that our workers are safe and that your community is safe, that we're not bringing anything in while we're doing work here. So it's something that if you're concerned about it, I would recommend reaching out. If you'll find out who the good partners are that you have, that if you're going to want to work with those people going forward. I found that even in that instance with the condominium association, that they came back and said, here are all the things that we're doing, and we agree that we will do this for your project. And then once you have that in place, I think there's some peace of mind and some protection for the association.
But some of that is going to be contract dependent.
Yeah. So then going in, if you've heard of it, a force majeure clause, generally the performance or delay in performance of an obligation under a contract may be excused when it's impossible, impractical, or financially infeasible. A force majeure clause, basically it serves to excuse performance as a result of an act of God, war, strike, riot, or etc. But what the case law has generally stated is that it must be explicitly provided in the contract, and the specific wording is important as to the event. So the actual events that are listed under the force majeure clause are very important. So if you don't have a pandemic, for example, it might not apply in your circumstance. Now, if it has maybe more broader language there, that's where its interpretation is required. Jim, anything else that you wanted to add, from the force majeure clause?
Yeah, so it's really going to be text specific. How exactly was the force majeure clause drafted in the contract at issue? Also, as this concerns the association, typically the association is going to be the one with a payment obligation, right? You're typically not the one performing services, although in some cases you might have contracts where you do have performance obligations. But generally speaking, force majeure largely excuses performance in doing something other than payment of money. I don't think we're going to be able to, on the association side, say, hey, landscaper, well, sorry, force majeure, we're not paying you for that work, right? It doesn't really work like that. That's not what financially infeasible means in this context. But it may, for example, maybe you have a certain vendor that said, hey, we would have otherwise performed under our contract, but because of the circumstances, we wanted to protect our employees, and therefore we didn't perform. And, I think many of those situations will be worked out practically. Of course, the association will say, well, fine, but we're not paying you because you didn't perform. It's going to excuse our obligation to pay because you didn't perform as well. But we won't consider the contract to have been breached. When are you going to start again, right? So the force majeure stuff, very text specific in how it's drafted in your contract. I think a lot of these issues will be worked out practically. And if you think this might come into play for your association or your community, or you have a contract where you're having vendor issues, we can potentially look at that, but it is very contract and language specific.
I think if anything, if you see it from a vendor, it might be if you have a project completion date and they say, look, I need to reduce my crew and I'm not going to get done by this time period. If there's a force majeure clause that might cover this, that might get them out of any of the per, from a liquidated, from a damages provision in the document for not completing it on time. That would be something that we could foresee happening. And again, it's document specific for your contract of how specific it is on this and whether or not that actually applies or not. All right, so going into the long-term effects, kind of our last thing that we wanted to talk about, and it's something that we mentioned if you came to us for this first webinar of what do we see we're kind of in the beginning phases of this, what do we think could happen from it? And I think the same thing from a long-term standpoint is what we were concerned about. Collections and financial issues, everybody's been looking up. I think Jim, even before we started, said, yeah, I'm looking up the most recent unemployment numbers and what the most recent filings were. That's going to have a toll. It might be more of a lagging indicator, basically, because if people are losing their jobs right now, they might be able to pay their assessments for the next month or two or whatever, but you're going to see that as a kind of maybe a lagging result of this in the next couple of months in the ability to pay assessments. Whether or not it's the same as the housing recession that we had 10, 12 years ago, I don't know that that's going to be the case. There's a question of whether or not how long this lasts. If we're already easing work restrictions again, are people going to start getting their jobs back? Or the unemployment numbers, is that going to get better? We're not sure. I don't think, by no means am I an expert on this. I don't know that anybody expects it to be a V, where you have all of this downturn, people losing their jobs, and then everything's going to go back up like this. We're not really sure what's going to happen for it, but I do think that there's going to be an impact from an assessment standpoint, which is the lifeblood of your community. You can only pay your vendors if your assessments are paid by your owners. And so having a collection policy for objective handling of delinquencies and having clear direction to management is really important. I say objective handling because you're going to have people that it might be your neighbor for a board member, and they say, hey, can we give this guy a break? And I think having a collection policy makes it easier for you as a board to say, look, we want to help them, but this is our policy, and we got to make sure we treat everybody similarly, because otherwise there could be a claim against us if there could be a selective enforcement argument, or there could be a waiver argument. You don't want to get into that circumstance where owners feel like they're being treated differently depending on if they know the board member personally or not.
You may have members of protected classes within your community, and if you have different timelines for pursuing foreclosure against them versus non-members of protected classes, then you might give rise to discrimination complaints. So there are lots of good reasons for having objective policies.
Yeah, we're still advising avoiding a waiver of payment of assessments or late fees. Treat those, if you have owners contacting you, try to work with them on either making payment plans or something like that. The statute basically says that you're not allowed to waive payment of assessments. Now, are there very limited circumstances where you could do that? We've seen that where if there's a short sale and there's a property that's about to go through foreclosure, those are very limited circumstances. For something like this where an owner is saying, hey, can you work with me? I've had some communities that have said, we're actually delaying our next quarterly assessments for the next 90 days. I'd advise against that. I would require it to be paid and then have owners contact you and then see what you're getting back from your membership. And if you need to suspend late fees and interest for further out than what you normally would, or enter into some type of payment agreement where you get the owner to sign it in writing. That way there's something that protects the association and also really protects the owner, because they have something that gives them understanding that, hey, instead of paying $150 a month, I'm paying $100 a month, but it's extended out and there's still an obligation for me to pay it, for example. But I would avoid being proactive on waiving payment of assessments or late fees and interest right now. Yeah. Electronic voting, we've had a number of communities that already gone through the spring where they're supposed to have their annual meetings. They've had to postpone those, whether or not they're ever going to be able to have them if they can make the quorum amounts. This is really for our HOAs that are participating right now, because the Condo Act has a specific process for nominating in advance that you don't actually have to make quorum in order to actually have an election. You're just required to have 20% of the owners cast a ballot whether or not they ever show up or even send in a proxy. As long as they mail in a ballot in the way that they're required to, you can have your election. For HOAs, though, a lot of your HOAs, for some of you that are in here, if you look at your bylaws, you might still have to take nominations from the floor, for example, which means that you actually have to have a meeting where a quorum is met before you can actually have an election. And so one thing is review your election provisions and consider amending your bylaws to provide for an advanced nomination process. What that means is basically the most simple way is kind of like what the Condo Act is, which is you have to get your name in by this date for you to be able to get on the ballot. If you don't get your name in by this date, you're not able to get on the ballot and you can't show up at the meeting and nominate yourself from the floor. If you have that process, then you don't have to worry as much about really making a quorum. You still have to have a certain number of owners cast a ballot for an election to take place. But let's say you have 5 people running for 5 spots. If you have a nomination in advance process, you don't even have to have the actual meeting. All you really need to do technically is show up, say we didn't make our quorum, but these people are automatically seated and therefore this is our new board. But for a community that has a nomination from the floor that still is required, those people who ran, even if you have 5 people running for 5 seats, they're not actually automatically seated. You have the previous board members are holdovers. So where I'm going with all this is really look at your election procedures as an HOA and then consider electronic voting. You don't actually have to amend your bylaws to provide for it. The statute allows for you to provide for electronic voting as long as there's a resolution from the board, and there's a couple steps you have to take for it. The owners have to opt into it, but I think that's a way for, even if this, people have been talking about that there's going to be a spike in the fall again, for example, we might have to ramp back down in terms of social distancing and closing things down again. That's going to impact any of you that maybe haven't had your annual meeting yet, but if you normally would have it in the fall, now's a good time to look at it if you should provide for electronic voting on the chance that even if, and this kind of leads into another talking point, which is we have not been advising clients. We've been saying you still need to have a physical location where the meeting is going to take place. But what some communities have done is say it's being held at this date, time, and location, but we're asking you please do not show up in person. We're going to be there to take your ballot from you, but we ask that you would go home and then you can participate if there's a Zoom meeting or if it's a telephone, a call-in, for example. So even if that's the case in the fall, by having a process for electronic voting, it's less likely that people are going to actually show up, right? But you're still going to have a process for people to be able to hand in ballots, and that's the process for HOAs as well as condos. So consider electronic voting to make it less likely that people are going to feel like they need to show up even in the fall if people are not still feeling safe that they want to have a big meeting of 100 people in one place at one time.
Yeah, another practical feature about implementing electronic voting is you can get a lot of people to participate in that way. Those of you who might not have the most productive of annual meetings, like people talking over each other and telling the board how much they appreciate so much, on all the time you donated for them. That's how these annual meetings go, right? Well, there's a nice feature if you use like Zoom software or something else where you can just, hit a mute button. So you can really control and regulate that 3-minute per member talking time.
And in reality, I've seen it done where we're the exact same function as what we have right now, which is the webinar function, which by default is we have the host and you have the panelists, which could be your manager and your board members. Everybody else is deemed to be our participant and they have to type in their question and you can go through one by one. I know the joke is that maybe even after this all passes that they might try to go to that, although you have to have your physical location, right? That's the biggest thing that we've been advising clients for membership meetings.
Right, for membership meetings particularly. And yes, nothing, even if the emergency powers apply, nothing in that statute changes the mechanics of how you have to hold a meeting. Right? It changes gives you a little more flexibility and notice of the meeting, but it doesn't change how you have to actually conduct it, unfortunately.
Yeah. So some possible statutory changes. This is just my hypothetical. I could see this coming out just from our discussion and some things we've discussed internally. One is statutory changes as to the emergency powers to include the pandemic or other emergencies that are not necessarily involving property damage. I think that's probably something that will come out of this in the next legislative session. We just talked about this, but allowing completely virtual board and membership meetings. So I know we had a question, I think it was one of the first questions that we had. Let's see here. Is there any issue with having votes in board meetings held via video conferencing? We've been advising clients that while you're still required to have the location of the board meeting for both condos and HOAs present in the notice, the fact that board members could already vote via FaceTime or telephone, we've been okay with having completely virtual board meetings, because what matters to me and what I've been thinking about is, what is the body that's entitled to vote? And if it's in a board meeting, it's the board members that are entitled to vote. And if they've already been entitled to vote, they don't have to be there in person. I felt more comfortable with allowing virtual board meetings, although it's not specifically stated in the emergency powers or anything else that you're specifically allowed to do that. But I've been okay with boards because I think that boards need to continue to operate. I'd rather take the risk of having a completely virtual board meeting, for example, rather than the board meeting by email and conducting their business via email where members aren't able to participate in that. Jim, what do you think about that?
Right. A couple of other points to piggyback on that. Here's what someone can argue, contrary to having a completely virtual board meeting, provided that you don't have some physical location where, someone could show up and view and participate in the board meeting in the physical location. Essentially, what someone could argue is you're forcing them to participate electronically, where the statute would otherwise require their written consent to participate in that manner, right? Although members don't have the right to vote, they have the right to attend and speak on agenda items for up to 3 minutes. So, technically, there's an opportunity to exercise that right if you disseminate the meeting information, the virtual meeting information to all the members. But again, you're forcing them to participate electronically, where they might not have consented in writing to do that. A couple of other options you can consider as a board. Depending on what your governing documents say, you may be able to take written action by the board in lieu of a meeting. What that doesn't mean is email. It's literally a written resolution establishing the action, and that must be unanimous, though, by the board. So if there's any board member, that doesn't really agree with the course of action or not sure, then that's not going to be an option for you. But you do have, though, potentially that option of not even having a meeting at all. You just have the written resolution in lieu of a board meeting. So that's another potential option. There are arbitration decisions recognizing that in the condominium context, which could be extended to the HOA context as well.
So yeah, I think that second bullet point really, I could see some potential changes allowing it, whether it's within the emergency powers, for example, to allow a virtual board and membership meeting if there's a state of emergency and it's deemed not necessarily because there's not a physical location. There's of course a physical location. The clubhouse is still standing. It's not like a hurricane event, but that you don't want people to be there because of a pandemic, right? Or whatever else that might be the case. So I could see that coming about. The third thing I put in was maybe I could potentially see some flexibility with use of reserves for other than their intended purposes. I don't know that will ever happen though, because you've had the emergency powers, and the flexibility that there is in the emergency powers is you have the ability to pass a special assessment against the members, contrary to anything that might otherwise require a member vote in your governing documents. And the legislature might think that is enough for the purposes of providing financial flexibility in the state of an emergency, for example. We've had some questions of saying, hey, we have owners that have stopped paying their assessments because they've lost their jobs and we have a financial difficulty. There's a state of emergency. Can we use our reserve funds? And I've stated there's nothing in the emergency powers. There's nothing anywhere that allows you to do that. And so then you're to the default rule, which is reserves are able to be used for their intended purpose unless you have a member meeting where the members vote by majority approval at a meeting where a quorum is met to use it for other than their intended purpose. So maybe there could be some flexibility for the use of reserves, but for everybody attending right now, if you have a question as to whether or not can I dip into my reserves to help supplement our operating, the general advice that we'd be getting is no. Unless you have a very broadly defined reserve account that's like a rainy day fund, which even then might not be a proper reserve account from the first place.
Right. In the HOA context, there is a limited possibility of an exception to getting a member vote, but it's very limited. Generally, condominiums, you're not going to have much flexibility there. But they're going to require a member vote.
Yeah. All right. So that's what we have for our PowerPoint, but I do have some questions that I want to go through. So we ask you if you can stick around. I'll be happy to answer some of these questions. And we'll take them for a little bit here. Bob had, I'm sorry, Lee, go ahead.
No, I apologize. I had a question for you all. One of the questions that I've been asked is we have had some boards that have adopted some rules and regulations for their amenity facilities with regard to social distancing and cleanliness and things like that. And so they noticed the meeting and it's been sent out to the membership, but it's not part of their recorded documents. So the question that they've asked me is, if there's a violation, can they enforce the rules and regulations just like, say, a policy in the declaration through the enforcement policies and fines?
So that's a great question. I think that where I was going to go is the first thing we look at is if it's adopted as a rule, do they have the authority to adopt the rule? 90% of communities that we've worked with, they have some language in their declaration that says that the board is able to adopt rules regarding common area or amenity use, or even as to the property use. So if you have that, that's the first thing, is to have the authority. Then the question is, rules are basically judged on a reasonableness standard, and that's what courts look at it, as opposed to something that is in part of the recorded documents that's been voted on by the membership might have a higher deference from the courts in that standpoint. So the question is this rule reasonable? And my initial reaction is, if it's something that's coming from federal, state, or local, health guidelines, it's probably, I don't think you'd have an argument from a reasonableness standpoint. So from that, if you go through and properly pass the rule and provide notice to the membership, the thing to remember though, Lee, I know you mentioned it's not part of the recorded documents, maybe not initially, but any changes to your rules and regulations for HOAs or for condos, those are considered to be governing documents. They're now required to be recorded in order to be effective. So if you are updating your rules and regulations, what we've been working with, if you've worked with us as a community before, I think it's within the last year or so that they've updated that. It's actually the last 2 years.
Yeah, it was basically an inadvertent change in the HOA context particularly. So they changed the definition of governing documents to also include rules and regulations. And by changing that definition, now HOAs have to record their rules and regulations. In the condo, it's less clear, but HOAs certainly, because of how governing documents is defined. So yes, record them, and then after you do record them, and subject to being reasonable, then your same enforcement tools are present, right? In the HOA context, fines, suspension of rights to use amenities and facilities, pre-suit mediation, lawsuit. In the condo world, you have pre-arbitration demand, arbitration. Of course, you have your fines and suspensions, and then arbitration or lawsuit. So yes, your same enforcement toolbox applies to those kinds of rules.
Thanks, Lee. That's a great question. Bob had posted about Alachua County. It had an update saying, in the update, the subject line looks like it says pools, public, or at condos or apartments must remain closed. But then in the context of the order, I'm reading it, the actual language, they don't mention actually private, condominiums or associations. So I think Bob's question later on was, does this actually apply to community associations? If you're in Alachua County, if there's a question on this, we're happy to take a look at it. It might be poor drafting maybe where they intended to include it or they think that it includes, but I would want to see something saying private community pools. We've seen it drafted, I want to say it was in Miami-Dade. Their order was fairly well drafted in terms of being specific, where I think the only exemption was for single family residences or townhomes, for example, where I joke that if you have a hot tub right outside on your patio that only you can use, even if it's a townhome, that was exempt. And the same thing if you have a pool or a hot tub with your single family residence, but all other, anything within a community association like a community pool or facilities were otherwise closed. From this, it might contain in the subject line, but it's not clear in the body of it, so we'd have to take a look at that further. All right, let's see. Melody posted the question of, we've been informed by our pool cleaning vendor that he was told by the health department and code enforcement that there was a $500 a day fine to have the pool open. We're located in Seminole County. I'd have to take a look at that. I'm not aware specifically what Seminole County has been requiring. We could take a look. We've had some instances where some of the vendors or some of the local health officials maybe are misinterpreting it, and we'd want to take a look at what they're saying, if that's actually part of the order, if it's written the way that they think it's written. So we'd have to take a look at that specifically.
Right, what the law or executive orders actually say, and what people, including government administrative agencies, perceive them to say could be two very different things.
Yeah. So Kathleen had the question, if we're opening the amenities, how can we enforce social distancing? I think Lee kind of touched on that as a good point of maybe, I would recommend passing it, go through the formal process of passing it as a rule. If that's what you're going to do and you want to try to enforce it, have a board meeting, properly notice it, adopt it as a rule, have it recorded, provide notice to all the members. That's your best way of trying to enforce it. But that's an after the fact type of enforcement. It's not an in the moment type of enforcement. And what I mean is, if you feel like somebody's in violation of anything that might be a local or a state order on this, you need to contact law enforcement on this and have them try to handle it. But if for the best way for the association, there's no great answer for how to immediately stop it, where we would certainly advise against board members or managers running down and trying to physically keep people from, don't go in there and try to rope people up and push people away and that kind of thing. Advise against it. Pass it as a rule, though, and you can send them notification as soon as practicable and then state that it's subject to a fine, and that may result in them stopping it too.
Yeah, your options for prevention on the front end are extremely limited. Most of the remedies are, punishment on the back end, if you will.
Yeah. So Deborah asked, can you post a sign that indicates use at your own risk and post CDC guidelines? I think that's something that we've been advising, use at your own risk, having some type of disclaimer language. And then you can say that, we recommend that you follow all federal, state, and local health and management officials and their guidelines, and you can post. I know the CDC has certain flyers that you can print out, and I think that's certainly appropriate to do.
Now, again, there's no force field that we can put over your community. So, hey, look, we had this flyer up, therefore you can't sue us. That's just simply not how it works. But they're an effort to devalue the claims, make them cheaper, meaning that, you can potentially fit more claims within your insurance policies and things like that. It's mitigation. It's not complete prevention of lawsuits. There's nothing we can do, unfortunately, that's legal to prevent that from happening.
Yeah. So a couple questions that are kind of related here. Well, the first one is regarding the election process. It says that if there is no advanced nomination process in the bylaws, does that mean there must be an election to allow nominations from the floor? That is the case for HOAs. For condos, you don't have that. It's by statute, a nomination in advance process. But for HOAs, if you don't have a process, even if, and this is what I say when I teach a board certification course about the election process, it doesn't matter what your community has done from a practical standpoint. It's what is in your bylaws that will control. And you could, as an HOA, you could be using the condo form of election for 10 years, and somebody could still challenge it on the 11th year, and you cannot use the past precedent as an excuse for it. The arbitrators have said it doesn't matter because the board could always change it. If you're going by what the board decides, then they could change the policy whenever there's an election and the new board can decide what the process is. That's why you have bylaw changes and why your bylaws will control. So yes, in that instance, if you don't have an advanced nomination process, you have to allow nominations from the floor, which means you have to make quorum. And if you can't make quorum, then all of the previous directors hold over, even if their terms are up. So that's why it's really important to look at your election procedures if you're an HOA. Jim, why don't you touch on this? There's a question of board votes. It's appeared it can't be by email. Is this correct? And just again, the statute says you're not allowed to vote by email. You're allowed to email to. You can use it as a tool of communication, but you're not allowed to vote by email. But can you talk about again, just real quick, about the unanimous consent?
Right. So you're right. You cannot vote by email. It's statutorily prohibited. Nothing in the emergency powers or nothing, as a result of the pandemic changes any of that. But there are ways to accomplish your business without actually physically meeting, one of which is unanimous written consent of the board in lieu of a meeting. Now, again, it's not the same as maybe what you would consider an email vote to be, which again is prohibited, where you say, okay, we have a majority of the quorum, so we're good. It's unanimous written consent of the board. The only other way to operate really is to, you can meet virtually, but again, subject to having that physical location for member participation, which is recommended. So you can meet virtually and avoid a physical location that way, at least for your board members. But voting by email is unfortunately expressly prohibited.
So last question, it's a good one from Michael. Is there any COVID-related liability with permitting food trucks in the HOA common areas? I mean, there's potential for liability. The joke is that you can be sued in by anyone at any time for anything. Whether or not it's a successful lawsuit is another matter. So I think that the theory of liability there would be if you allow a food truck in, if somebody in the food truck, of course, has COVID-19 and the association didn't check it, and you can somehow prove that that person gave it to members that used it, that could be a potential liability. I think that there would be a very clear defense that those owners are making the decision to go up and get the food and knowing that they're touching a surface or coming in close contact with somebody potentially. So again, whether or not there's a successful lawsuit, I think it depends. For a lot of this stuff, it's a time to take a look at what insurance policies you have in place and whether or not you'd be coverage under a theory of liability for something that's wrong with this.
Yeah, and another related issue. So part of it is, what are the food trucks doing? What are they serving? Are they serving alcohol? Yes or no? If you're inviting them into your premises, typically the association as the entity is not getting any benefit from that. But these food trucks are commercial businesses, and they are. So one thing to consider is mandating that any food truck that comes onto the property, they have to get a certain level of insurance, which you need to work with legal counsel on the specifics of that. They have to get insurance. They have to name the association as an additional insured under that policy. And you have to look at the content of those policies to make sure there are no exclusions for potentially virus transmission. Another issue is if they're serving and you're serving alcohol, they should have social, the social host liability policies, policies covering, basically alcohol-related injuries. And again, naming the association as an additional insured. Otherwise, you would be exposing the association to risk without anything in return, really.
It comes down to what we've talked all about. It's risk tolerance from the board.
Yeah.
Obviously, if you're serving alcohol, that adds a much higher level of risk in our opinion. If they're not serving alcohol and it's more related to, well, they're coming in and how do we know if they've been monitoring or if they've been self-quarantined, all that stuff. That's difficult to prove anyways, that if somebody got that from a food truck, that if, going to the contact tracing and all that kind of stuff. But as Jim stated, if you want to be more conservative with it, that would be the best approach, is to make them provide you with that information, indemnification, defendant, there's a whole host of things that you can look at. And then it just comes down to the board might say, look, I get it, there's a potential, but what if we allow it under these circumstances? And can you work with us as legal counsel to help us accomplish that? We'll help you through it all, but there's always the most conservative way. And it just depends on what the level of risk tolerance is for the association.
Right.
So, all right, well, that's what we have for today. Lee, did you want to make any final comments before we log off here?
No, I just want to say thank you again, gentlemen. As always, this is very informative. It's very helpful to our clients and our visiting association members. So we really appreciate the time that you're putting in, and we're glad to partner up to get this information out to as many people as we can. Thank you.
Absolutely. Thanks, Lee. And thank you to Vesta for being so committed for providing education opportunities and providing this for, your board members. I think it's a valuable tool, and we try to do what we can, but you've heard us give us some lawyer speak in terms of we can't give you concrete answers all the time, but we can try to at least guide you as best we can on it. And we have our contact information. We're happy to assist with your community if you want to reach out to us. All right. Well, thanks, everyone. And everybody stay safe, and we'll be on the lookout. I'm sure we'll be doing some more education events in the future, too.